I was just waiting on Mr. Molefe to just finish signing the affirmation.
Thank you very much.
Yeah. Mr. Molefe, sir, can you, for the record, state your full names?
Brian Molefe.
Is it correct that you have prepared a statement? It's a 20-page statement dated the 21st November 2017?
It is indeed correct.
And that you have furnished the committee with annexures to your statement?
Yes, it is correct.
With your permission, the statement has been furnished to the members of the committee, and subsequently, because these proceedings are open, it will be furnished to members of the public. Have any difficulty with that?
I do not have a difficulty with that, Chairperson, but I would like to read the statement.
In all fairness, if you want to read the statement, please do so, sir.
Thank you, sir. I arrived at Eskom in April 2015. During this period, Eskom was experiencing load shedding, which was having a debilitating effect on the South African economy as well as on Eskom. Evidence to this is on page 21 and 22 of the annexures. The staff morale was very low. The South African public was generally angry with the utility because of the hardship that load shedding was imposing on them. The fastest growing app in social media was called Eskom Se Push. This, for me, summarized the extent of public anger and frustration at load shedding, which was generally seen as Eskom's fault. I saw my first task as being to instill a fresh sense of purpose and improve the morale of all staff, including senior management. We embarked on a program to improve the maintenance of Eskom's fleet of electricity generating plants. This led to the development of the strategy called Tetris by some of Eskom's young engineers, which we have briefed this committee about during previous meetings. My view is that this strategy, as well as the implementation thereof by Eskom employees, contributed immensely to the end of load shedding, which stopped in August 2015. In this respect, Lyle Team, a young engineer at Eskom, his team, all the power station managers and the generation team deserve special mention. The Glencore contract. Glencore was, during this period, one of Eskom's coal suppliers. Their Optimum mine had a 25-year contract to supply coal to Eskom's Hendrina power station. This contract is due to expire in 2018. A copy of the contract can be obtained from Eskom. In terms of this contract, Optimum was obliged to supply coal of a certain quality to Eskom at 150 rand per ton until 2018. So there was a contractual obligation to supply coal at 150 rand per ton until 2018. The contract also specified that should the coal quality be below certain specified levels, Eskom could impose a fine on Optimum. A penalty in terms of this contract had previously been imposed by Eskom in 2012. But there had been on and off negotiations with Glencore on the penalty for about 3 years. By 2015, when I arrived at Eskom, I was advised that if we do not take steps to recover the debt, the amount owing on the penalty could prescribe. In May 2015, I became aware of Glencore's request to increase the contracted price to 530 per ton, from 150 to 530 rand per ton. This was in essence a request for a variation of the contracted price in favor of Optimum and its shareholder, Glencore. In addition, they wanted the penalties that had already accumulated in terms of this contract, about 2.1 billion rand, to be waived and set aside by Eskom. Their reason for wanting these variations was hardship. This request, when I arrived at Eskom, was being favorably considered by Eskom. However, when I looked at the request, I could not support it. Glencore's hardship was nowhere near Eskom and South Africa's hardship as a result of load shedding. I could find no reason to entertain this request as we had legally binding agreements on the price of coal as well as the penalties. For Eskom to have agreed to this request would have been irresponsible in the light of what the company was going through. We met with representatives of Glencore and made it abundantly clear that their request could not be entertained because Eskom's own position was precarious. I note that during this inquiry, P.S. Marsden, who became the business rescue manager of Optimum, characterized our stance in response to Glencore at the time as being commercially sound. I couldn't agree more. Glencore's position was that if they did not get the price increase, they would stop the supply of coal to Henrina, and they emphasized that this could result in more load shedding. In fact, it was during a meeting with Mr. Ivan Gleisenberg when he told me that they would stop the supply of coal and this would result in more load shedding. And I said to him, if you're putting a gun to my head, sir, please shoot. After the possibility of termination of supply was mentioned by Glencore, we started working on increasing the coal stockpiles at Henrina. I knew that Eskom and the country could not be held to ransom by a supplier of coal who was prepared to let South Africa suffer crippling power shortages to secure an increased price. The additional cost to Eskom of such an increase would have been in the region of 1.98 billion rand per annum. So if you take the increase over the remaining 3 years of the contract, which was from 2015 to 2018, it would in fact come to just under 6 billion rand additional to what Eskom was under no obligation to pay, but that was being requested by Glencore. Minister Ramatlhodi and Glencore. At about this time, the Department of Minerals announced that Glencore's mining licenses have been suspended. If you look at the annexures, pages 24 to 25, which was the announcement of the Glencore's suspension of Glencore's mining licenses by the Department of Minerals. The reason for the suspension was that Glencore had not followed due process in the proposed retrenchments of their workers. The effect of the suspension of the mining licenses would have been to guarantee the suspension of coal supplies by Optimum to Henrina. In fact, for the period when the licenses were suspended, there was no supply of coal by Optimum to Henrina Power Station. We were relieved when a few days later, the suspension of the licenses was withdrawn. I was dumbfounded when in May 2017, former Minister Ramatlhodi claimed that the Eskom chairman, Dr. Ngubane, and I met with him to ask him to suspend Glencore's license, and that he refused because it would result in more load shedding. He seemed to have forgotten that he had in fact suspended the license at the time, and in fact we had requested him not to suspend the license because it would result in more load shedding and it would result in meeting Glencore's desire not to supply coal to Hendrina at 150. Business rescue. In early August 2015, Glencore decided to put Optimum in business rescue. A business rescue practitioner, Piers Marsden, was appointed. Within 48 hours of being appointed, the practitioner wrote to Eskom saying that he requires us to increase the price that we were paying for Optimum coal. Otherwise, he will have to stop the supply of coal to Hendrina, which would result in more load shedding. The supply of coal to Hendrina was indeed suspended by the business rescue practitioner in August. He admitted to doing this when he gave evidence here. For about a month, we had no coal from Optimum, and we supplied Hendrina from the stockpiles as well as through scavenging from the small coal miners in the area. Despite not having the coal from Hendrina, we never closed down the power station. The month of August also happened to be the month in which Tetris started showing results. Plant availability improved sufficiently to stop load shedding. However, if Hendrina had been closed because there was no coal, load shedding would have continued. Load shedding stopped in spite of the fact that Optimum was not supplying us with coal. In his evidence in this inquiry, Piers Marsden confirmed that they used the business rescue rules to avoid entering into arbitration proceedings with Eskom on the 2.1 billion rand penalty. He also said that Eskom did try to take the matter of the 2.1 billion penalty on arbitration, but they resisted it. In September 2015, Mr. Clinton Efron of Glencore, and not the business rescue practitioner, called me to say that they would resume coal supplies to Hendrina at 150 rand per ton, which we accepted. Subsequently, Glencore intimated that they would like to sell Optimum. We told him that that was their decision, but that they must know that our price of 150 per ton stands until 2018, irrespective of who the owner of the mine is. Similarly, the penalty of 2.1 billion would remain payable. This was confirmed also by Piers Marsden at this inquiry, and even went on to further to say that he thinks that Pembani could not meet these conditions, and that is why they didn't do the deal. He said that in his evidence here. The sale of Optimum. Glencore, after entertaining several buyers, sold Optimum to Oak Bay. The deal was approved by all the creditors of Optimum, mainly South African banks, as well as the Competition Commission. At the time of the sale, the price of coal for Hendrina remained 150 rand per ton, in line with the agreement, and the 2.1 billion penalties remained payable by the new sellers. Pembani had also indicated their interest in buying the mine. When we indicated that the 150 rand per ton as well as the penalties will remain payable, their view was that the deal was not attractive. They walked away. Incidentally, Piers Marsden also confirms in his testimony to this committee. The pension payment from Eskom Pension Fund. I don't know if we should deal with Optimum and then go to the pension payment, or do everything and then take questions later.
Yeah, I think just finish your presentation.
Okay, the pension payment from Eskom Pension Fund. In April 2015, I was seconded from Transnet to Eskom as Group Chief Executive Officer in an acting capacity. On the 2nd of October 2015, I received a letter from the Minister of Public Enterprises appointing me as Chief Executive Officer of Eskom and ex-officio member of the Eskom board. The letter did not have a limitation on the period of employment. The letter is attached page 29 to 30 of the annexures. Also in October 2015, I also received a letter from the chairman of Eskom, Dr. Ben Gubani, confirming my appointment as Group Chief Executive Officer. There was no limitation on the period of employment. The letter is on page 31 to 34. Unfortunately, Chair, the letter that was given to me had been signed, and I signed it and returned it to Eskom. Unfortunately, I did not keep a signed copy, but in my records I found a copy of the letter before it was signed by the chairman and myself. Also, in early October 2015, I received and signed the executive employment contract that is attached in page 35 to 49 from Eskom, which specified the commencement date of my employment as the 1st of October 2015, and the contract specified that employment was to continue for an indefinite period. Clause 3.1 of the contract, which is on page 39 of the documents. In November 2015, my membership of the Eskom Pension Fund was finalized. I also transferred proceeds from my Transnet Pension Fund to the Eskom Pension Fund, which was about 4.3 million rand. The Eskom Pension Fund loaded my membership in their system as PPX, meaning that I was a permanent employee. On the 1st of November 2015, the minister wrote a letter to Dr. Ngubane informing him of a cabinet decision to employ all the parastatal executives. This is an edit that I would like to, I just said all the parastatal executives, but it's parastatal executive directors, which is the parastatals executive directors, which is Eskom's executive directors on 5-year contracts. This meant that my contract of employment would be changed from a permanent contract to a 5-year contract. That is on page 50. The minister's letter is attached on page 50 of the documents. On the 9th of November 2015, I received a letter from Dr. Ngubane advising me that I will be required to enter into a fixed-term contract of employment, which is page 52 to 54. I note that when Ms. Daniels was giving evidence here, my employment contract documents for her start with this letter and not with the letter of the minister of the 2nd of October, which is a very, very big omission in my opinion. On the pension fund as well was misled by this letter of the 9th of November, which simply forgot that I had already been employed on the 2nd of October by the minister on an open-ended contract, and I was a member, therefore, of the pension fund. On the 25th of November 2015, Dr. Ngubane wrote a letter to Minister Brown. And this letter I have attached on page 55 and 56. In that letter, he requested that at the end of the 5-year contract, I be allowed to retire from service as if I'm 63 years old. Penalties prescribed by the EPPF be waived, and Eskom would carry the cost of the penalties. The letter of 25 November 2015 from Dr. Ngubane, which, by the way, had been written because I had asked members of the board and the PNG, when you change my contract from a permanent employment contract to a 5-year contract, what will happen to my pension? I asked that question because I had just come back from a 4-year stint at Transnet. My contract of employment at Transnet had actually been renewed for a further 5 years, which means that I would finish 10 years at Transnet. But now I was sent to Eskom. I was requested to go and assist at Eskom because of load shedding. And so I asked, what will happen to my pension? And then there was a presentation by the specialist at Eskom to the board and the PNG to say that we will recommend that when you leave, we pay your additional pension to make up for your agreeing to change your contract from permanent to 5 years. That is what happened, sir. Sorry, Chairperson. The letter of the 25th of November 2015, which specified these new pension arrangements, was sent by the Eskom Company Secretary, Ms. Suzanne Daniels, to Ms. Kim Davids, the Minister's PA, Osila Rathman, and Z. Mbilasi at the Department of Public Enterprises. The letter was emailed at 20 hours 33 on the 25th of November 2015 by Ms. Daniels, and the proof of that is on page 57 of the documents. At 21:05 on the 25th of November 2015, Ms. K. Davids acknowledged receipt of the letter and undertook to bring the letter to the minister's attention. And this acknowledgement is on page 57 of these documents. On the 26th of November 2015, K. Mhlongo sent an email to Ms. S. Daniels confirming that the letter will be brought to the minister's attention, and that is on page 59. Also, Osila Radman noted the letter, and her email is on page 60 of these documents. On the 9th of February 2016, the People and Governance Subcommittee of the Eskom Board, PNG, received a presentation from Mr. A. Minar. Now, please note, sir, Chairperson, that by this time, the letter about my pension arrangements had been with the department since November, and there had been no response. There's a section in the PFMA, I think it's section 54, which says if the executive authority does not respond within 30 days, approval has been granted. So I don't know. I think I cannot speak for the PNG or the board, but maybe they labored under the presumption that they have given the minister this information, and in fact that letter requested approval for my pension arrangements, but there had not been a response from the department. So the People and Governance Subcommittee of Eskom received a presentation from Mr. Anton Minar on the 9th of February 2016, where he reported that a 5-year contract, the presentation and the minutes of the meeting of that date are attached as page 62 of the documents. He reported that the 5-year contract for the Group Chief Executive of Eskom is a first for Eskom. And I think Ms. Venetta Klein was at pains to say that that threw them in a spin during testimony this morning. He also referred to previous precedents at Eskom, where additional pensionable service was granted to executives and penalties were waived. Incidentally, when the EPPF was here, they also confirmed that this had been done before. And Mr. Brian Dames, in his evidence here, also said, my last request as he was leaving Eskom was, just like the other previous chief executives had received the patches of their years and so on, he also requested it. I don't know if it was granted, but he did say in his evidence that he also made that request. Incidentally, it would be interesting to see how far back this practice goes and which chief executives were paid in this manner or had their pensions arrangements in this manner. During the court hearings that are now going to the High Court next week, during the process, we have requested through Section 35 of the Rules of the Court from Eskom and the Pension Fund information about who else received this kind of arrangement. And both Eskom and the pension fund refused to tell us or to put it on record at court that these are the chief executives who received these similar benefits when they left. So perhaps this committee can shed more light on that issue by the time the inquiry is finished as to which chief executives and how far back does it go that similar arrangements were made. By the way, because the pension fund is a defined benefit fund, the benefits are defined. So it is, one has to, the contributions are really not an issue, but it's the benefits that, that are defined by defined benefit fund. During this meeting, the PNG made a resolution, which is attached on page 63, that the Eskom, the resolution I've attached on page 63 of the documents, the Eskom pension fund rules that employees may proceed on retirement from age 50 with 10 years service remains applicable. This was a resolution of the EPPF. And it also said, where executive directors, not specifically the group chief executive of Eskom, but where executive directors on fixed-term contracts take early retirement, and there is a shortfall regarding 10 years, the 10 years, Eskom will bridge the gap, waive penalties, and refund EPPF costs. This resolution was taken by at the meeting of the PNG. I note that Mr. Brian Dammers testified recently before this committee that there was a practice at Eskom to permit executives to take early retirement from Eskom. Mr. Sibusiso Luthuli, Principal Officer of the EPPF, said that Pension Fund Rule 28 permitted normal retirement from the fund at age 50 with the permission of the employer. If I can read you that part of the rule. The rule. On page 80 of the sorry, page 84, section 28.3 says that no, it's on the page 80 of the
Ignore,
yes.
ignore that they must talk to, they must direct their queries to me, so
Okay.
that you don't get distracted.
Page 84 of the documents that I have submitted. Subsection 3 says, with effect from 4 March 2000, if a member who has attained the age of 50 years or who had attained the age of 45 years and who is listed in Appendix 10 of the rules and has not less than 10 years pensionable service becomes entitled to a benefit in terms of this rule, he may instead be granted at the discretion of the board after consulting the employer as from the date of his leaving the service of his employer, a pension in respect of his pensionable service calculated in terms of Rule 22 without reduction in terms of Rule 24. This is the rule that actually led to a lot of confusion, because in fact if you go back to just before you get to section 28, it actually talks about retrenchments. So this rule is interpreted in fact to mean that it would only apply in the case of retrenchments. However, when you go to the members' guidelines, the members' guidelines simply took that rule and put it in the guidelines as if it is permissible for a member who is over 50 years old and who has the permission of the employer to go on early retirement. And the members' guidelines under section 3.3 page 68 of the documents, says a member between the ages of 50 and 63 may go on early retirement without penalty and without potential service by mutual agreement with the employer, where the employer will pay for the cost of early retirement. That is the penalty. Members between the ages of 50 and 55 need to have contributed to the fund for a minimum of 10 years in order to qualify for this benefit, which means that if the employer agreed, the employer could also pay in the 10 years, which is in fact what happened, that Eskom paid in the 10 years in terms of the guidelines. But later on we discovered that this was in fact not so, strictly speaking, in terms of, we even disagreed with the pension fund. We had made a mistake. We could not apply this rule in my case, and that is the subject of the court case. The guide informed my understanding of the EPPF rules and was referred to by Mr. Minar in the PNG subcommittee referred to above. On the 11th of November 2015, I wrote a letter to Dr. Ngubane requesting early retirement in terms of the rules of the EPPF and the resolution of the PNG meeting of the 9th of February 2016. Chairperson, you'll notice that I wrote a letter requesting early retirement. I did not write a letter that says, I hereby resign. I wrote a letter requesting early retirement. That letter that I wrote on the 11th of November 2015 is attached as on page 85 of the documents, the actual letter that I wrote. On the 24th of November 2016, I received a letter from Dr. Ngubane communicating the Eskom board's acceptance of my early retirement. That is attached on page 86. On the 18th of February 2017, I received a letter from the Eskom Pension Fund welcoming me as a pensioner and providing details of my pension, which is attached on page 88. In fact, if you read that letter, you will see that I did not receive 30 million rand. So, I did not receive 30.1 million rand as has been widely reported. I received a lump sum of some 7.7 million from the EPPF on being admitted to the fund. Of this, 4.3 million had been transferred by me from the Transnet Pension Fund to the EPPF when I joined the EPPF. In April 2015, after I had accepted appointment as a member of the National Assembly by the Northwest Province of the ANC, members of the Eskom board and company secretary met with me and intimated that the acceptance of my early retirement application was a mistake. I asked them to make a proposal on a way forward that would get the Minister of Public Enterprises approval. On the 11th of May 2017, I received a letter from Dr. Ngubane requesting me to resume duties as Eskom Group Chief Executive. That letter is attached, page 90 to 91 of the documents. Because of the common error of implementing the early retirement, the legal position was that the situation had to be restored to status quo ante. I obtained legal advice which confirmed that that was indeed the legal position. I signed a reinstatement agreement, which is on page 92. The reinstatement agreement did not seek to reinstate me. The fact that my pension arrangements or my pension agreement was void ab initio means that my contract of employment was still in existence, and that is what the legal advice that we obtained. And so the reinstatement agreement just regulated the manner in which I would return to Eskom on the date that had been specified by the chairman of the board. Eskom also assured me that the minister was comfortable and had approved this arrangement of the rectifying of the common mistake. Ms. Daniels, in her testimony to this committee, indicated that such approval from the minister had been obtained, page 90 to 91 of the documents that I have attached. On the 15th of May 2017, I resumed duties as Eskom Group Chief Executive in terms of my earlier contract of employment. On the 17th of May 2017, the Eskom Group Company Secretary wrote a letter to the Principal Officer of the Eskom Pension Fund advising him of my resumption of duties at Eskom with effect from the 15th of May 2017, and further advising that my membership of the pension fund must be reinstated. That letter is attached, it's page 96 of the documents. On the 15th of May 2015, the Democratic Alliance launched an urgent High Court application to challenge my resumption of duties. This was followed by an application by the EFF. The matter was originally set down to be heard on the 2nd of June 2017. I have submitted all the documents, all the affidavits, all the court records relating to this matter of the DA and the EFF, as well as which was later joined by Solidarity. All the documents have been submitted, were in the suitcase that I brought with me. On the 31st of May 2017, Minister Brown sent a letter to Dr. Ngubane instructing the board to rescind the decision to reinstate me as Group Chief Executive. An interesting thing about this decision to rescind the decision to reinstate me was that in that agreement that regulated how I would come back, I had agreed that because of the common mistake, the money that is due to the pension fund must be paid back, and I agreed to pay the money back by November this year. But now the agreement has been unilaterally rescinded, and so I don't know where the issue of the paying back of the pension money is, because I had agreed that, okay, the mistake was made, I would resume duties and I would pay back what had been paid by the pension fund, which was not 30 million, by the way. It was the 7 million, which included the 4 million that I had contributed, as well as pension payments for the month of January, February, March, and I think April. And this whole matter of how much I owe the pension fund and what the way forward is will now be determined in the High Court. We're going there next week on the 29th to the 1st, and I presume that after that we will go back to the Labour Court. On the 24th of May 2017, Solidarity launched an urgent High Court application seeking to review various decisions concerning my resumption of duties and related relief. On the 2nd of June 2017, after a brief Eskom board meeting, I received a letter from Dr. Ngubane advising me of the minister's instruction to rescind the reinstatement. This letter is attached as page 99 of the documents. On the 5th of June 2017, I launched a Labour Court application to set the summary dismissal aside. On the 6th of June 2017, the High Court application was postponed pending the outcome of the Labour Court application by the DA and the EFF. On the 4th of July 2017, the Labour Court issued an order postponing hearing my application until after judgment in the High Court applications brought by the DA and the EFF had been finalized. This was a very interesting judgment because I had been an applicant in the Labour Court matter, but the judge referred me to a matter in which I was a respondent and said that matter must be finalized first before she would hear me. It was very surprising, but nevertheless, we then went back to the High Court, and the High Court will hear the applications from the 29th to the 1st of December 2012. The Public Protector's report. The Public Protector released a report titled State of Capture Report dated 14th October 2016. The report contained a series of observations and did not make any findings. Paragraph 5.96 to 5.101 deal with my phone records and makes some notes. I have repeatedly heard, I think, Mr. Swart in these proceedings talking about findings. Although the Public Protector makes the notes, she did not ask me for my side of the story as regards the phone calls, nor did she bring the phone records in her possession to my attention before she finalized the report. An important principle of our Constitution is the right to be heard. This was denied to me by the Public Protector. She did not hear me at all on the matter of the phone calls. Secondly, the Public Protectors Act requires her to inform whoever may be implicated by the evidence that she has of the evidence and to ask them for their side of the report. She did not do so, and therefore I have not had an opportunity to ask her or to talk to her about those phone records. Significantly, however, the Public Protector's report did not make any findings as regards her notes or observations relating to my phone records. And we have toed and froed, and I think Ms. Klein referred to this earlier in her testimony and said that because there were no findings, we could not ask for a review. There were no findings about my phone records. And so the questions that the lawyers asked was, but when you ask for a review, what are you asking to be reviewed? Just a note or an observation by the Public Protector, which does not carry, I was told, any weight at all until it is converted into a finding. In fact, in the Public Protector's report, Advocate Madonsela said these matters need to be investigated further. And we were hoping that the Public Protector would continue with the investigation. But perhaps her feeling was that the Public Protector's office was coming to an end with her term. Nevertheless, paragraphs 5.97 refers to contact between myself and Mr. A.J. Gupta on a number of occasions. The Public Protector fails to provide any other details about the phone calls. She does not provide the phone numbers, nor the dates and times when the phone calls were made. It is therefore difficult for me to determine the veracity of her claim in paragraph 5.97 of the report. Similarly, paragraph 5.98, there are no details of the phone numbers or the dates and times of the phone calls. I can therefore not confirm or deny the veracity of the claims. In paragraph 5.100, the Public Protector says I can be placed in the section world area 19 times. That is all that is said. She does not provide context or even suggest what I may have been doing there. What I understand from inquiries made to a communication expert is that any user of a cell phone within the area of a coverage of a cell phone tower, for example, Linwood, will be recorded as being in the area of, say, Linwood. This includes a user who is in transit through the coverage area of that tower. But more importantly, paragraph 5.99. I don't know if, Madam Chair, you have the Public Protector's report. Paragraph 5.99, if you go to it, it's a graph that shows the number of times that I was in the section world area. You will need a magnifying glass to read that, because I struggled with that graph for many months until I could understand it. But entry number 1 to number 10, which is 10 visits to the Section World area, happened in a period of 20 minutes. If you get a magnifying glass, I have one. I carry one with me just to read this report whenever I can. I don't know where it is now. The magnifying glass. Yes, Mr. Everett. Prof. The public protector says I was there. So the 599 suggests the number of instances that I was perpetually in the Section World area only shows that I was there 5 times and not 19 times. On the 5th of August, when according to the cell phone service providers' records, I was in the area between 09 hours 17 and 09 hours 41 and made 1 phone call and received 9 others. Incidentally, when I viewed my records, about 4 minutes before and about 5 minutes after I had made the last and the first phone call, I was in fact outside of Section World, which means I did not stop for a meeting. For 20 minutes, I received 9 phone calls and made 1 phone call, and the public protector reported that I had been to Section World 10 times. The 17th of August, when according to cell phone service providers' records, I made 2 phone calls while I was in transit in the area. The 18th of August, when according to cell phone service providers' records, I made 1 phone call while I was in transit in the area. 23rd of August, when according to cell phone service providers' records, I listened to my voice messages while in transit in the area. And on the 28th of August, when according to cell phone service providers' records, I received 2 calls, listened to my voice messages, and received 1 call while in transit in the area. Paragraph 5.101 says that I had contact with Mr. Atul Gupta. This is not true, because the phone call from Mr. Atul Gupta to myself was forwarded to my message box. There is no other record in my phone records that shows that I returned Mr. Atul Gupta's call or that he ever tried to contact me again. The public protector recorded it as contact with Mr. Atul Gupta. This is according to my cellular phone records, which I have thoroughly examined since the release of a report. I would have raised these and other discrepancies had Ms. Madonsela afforded me an opportunity to present my side of the story or to get clarification